Hello and welcome to a new episode of Corporate Culture, your podcast about cooperation, conflict, and culture at work. Today I speak with Tobias Vollmer. Tobias Vollmer is a senior director at RAEDAS, which is a global corporate investigations and dispute resolution consultancy based in London. He focuses on evidence gathering in support of international litigation and arbitration, and routinely works on cross-border and multi-jurisdictional disputes spanning the Commonwealth of Independent States, Middle East and the North African region, sub-Saharan Africa, and Asia. Dear Toby, thank you for joining today.
Thanks for having me, Paul. Really much looking forward to this.
Great to have you. Toby, as a joke, I often say that you are kind of a detective. Could you say that this is a good description of your work?
I guess to a certain extent it is. I personally don't like the term too much because it sort of evokes a picture or an image of, running around with a magnifying glass and, in disguise like Sherlock Holmes, which is not quite true because a lot of the work we do is desktop based. We pore over lots of documents, search for the piece of evidence that will crack a case open, and so on and so forth. Sometimes we go on the ground and we look for evidence in other countries and speak to people and all sorts of things. But I don't think detective is the ideal term to really describe what we do.
Okay. If you could describe your work in easy terms, what are the things you do in your everyday life?
So our clients tend to be law firms that represent multinational corporations and high net worth individuals, sometimes states or state-owned entities in commercial disputes, more or less, when two parties have a dispute around a contractual obligation of either side. We are instructed by the law firms most of the time to then gather evidence to support their claims or support their legal proceedings. Mm-hmm. So on a daily basis, I would say we look for evidence, we look for assets, we look for intelligence sometimes, although we try to get as much documentary evidence as possible, but sometimes that evidence is confidential and it's very hard to come by. So in those cases, we will look for evidence for intelligence, which sometimes may be helpful as well to sort of progress a case and progress the understanding of what is going on in a particular dispute.
Mm-hmm. Okay, I understand. As this podcast is a lot about conflict as well, I would like to ask maybe more into this direction. You already mentioned that you work especially in arbitration, litigation cases. Could you maybe describe what kind of conflicts play a role in your work?
So the way that I would describe the conflict in the project or the cases and matters that we do is a legal dispute, an international legal dispute, either fought in national courts, that would be litigation then, or in international tribunals, which would then be called arbitration. Mm-hmm. And the disputes range from various things, as I said, sort of, around commercial issues such as contractual disputes, sometimes divorce, although we tend to try to stay out of those because they can get quite messy. In general, it's around the breakup of a relationship between either two parties, be it a private party, a public party, between two corporates, two businesses, or two businessmen who were partners at some point and fell out and suddenly need to sort out their conflict through, legal means by, going to the court, having a third party, a judge or an arbitrator or an arbitral tribunal decide who's wrong, who's right, or to what extent someone is right or wrong.
Mm-hmm. You mentioned that you work usually for law firms. Do you still have some insight into the roots of the conflict? So how do these conflicts arise? And also, what is the reason, or when do the parties decide to say, okay, we cannot solve it alone anymore, we have to go into an arbitration or litigation process?
We do understand the context of the disputes most of the time. Sometimes law firms are not really forthcoming with the exact, details of what happened. Sometimes they don't know either. And that's where we come in sometimes, where we have to sort of investigate what was going on 10 years ago around a certain, either expropriation of an asset, which then leads to, a legal dispute because one side lost their assets that they had invested in a foreign country, for example, or when it comes to sort of mergers and acquisitions that go awry, sometimes you have to sort of investigate what went wrong. Was there any fraud involved? Was there any corruption involved? Bribery, money laundering, and so on and so forth. Sometimes when it comes to sort of very prominent cases that have been fought in the High Court in England and Wales, revolve around partnership agreements between, let's say, two Russian businessmen that say, okay, 20 years ago, we shook our hands on this deal saying we will be 50-50 partners. There's no written agreement. Suddenly you need to investigate and find evidence for either side's claim, saying, I was a legitimate 50% partner in this. So we try to understand the roots of the dispute or the conflict as much as possible, because when we look for evidence, we need to understand what is relevant evidence, what is, valuable pieces of information that will help our client's case. So, we try to be as much part of the legal strategy and the legal team as possible, because when we go out and look for evidence, it's just really important that we understand A, the conflict as such, or the dispute as such, and B, what the legal strategy of the legal team is and what the client wants to achieve. So as much as possible, we need to know what the dispute is really about.
Yeah, makes sense. Could you give us some examples of concrete measures you are taking in your job when you're saying you're collecting evidence? Is it mostly an online research? Is it meetings with people in person? Is it a lot of travel? Are you a lot like going around the world? Like, how can we imagine the work you're doing?
So it's definitely a combination of both, where we do a lot of online research. We've got lots of proprietary databases that we use. At the same time, a lot of information lives on the web nowadays. You won't find a lot by a simple Google, but if you know where to look, if you know certain websites, or you sort of try to understand what you're looking for, a particular piece of information surrounding a property, for example. In certain jurisdictions, property records are very vast. For example, in the US or the UK, you get a lot of information about planning applications, which will then help you understand whether a property is owned by someone. Often, we come across properties that are owned through shell companies registered in, jurisdictions like the British Virgin Islands or the Cayman Islands or elsewhere. And often it's not quite clear who the beneficial owner of these is. So you have to sort of go a step further and sort of look for all sorts of documents, transfer documents, other deeds of trust, planning applications, as I mentioned, to really understand, okay, who's behind this property and who's behind this company.
Yeah.
So on the one hand, we do this sort of online research. Part of that is also actually going to archives or going to registries where certain information might not have been digitized. So some information might not live on the web yet, but they will have it. Either you call them up and say, look, I'm looking for this piece of information. Do you have it? And then they might be, willing enough or prepared enough or, kind enough to actually go look for yourself. Or in some instances, you will have to go to that registry, be it, in Tanzania or Peru or wherever, where you think that piece of information will lie, and then you will have to go yourself. And either, they let you go into the archives, or sort of by your being there, they will be more prepared to actually look for it. So that's one part of sort of how we go about looking for evidence. The other part is speaking to people, because as I said, we try to understand the conflict as much as possible, but sometimes the client doesn't know what happened, or they have an idea what happened because something went wrong. Suddenly, they had an asset, they had an investment, suddenly it's gone. The state expropriated it, or something happened, and a lot of that information will not be public, because inherently, we're dealing with crimes, often financial crime, fraud, and so on and so forth. So people don't tend to write down their crimes. So you would have to then talk to people who might be privy to that information, who might be privy to the events that occurred. So we'll have to find, former associates. Maybe you find, ex-business partners who have fallen out and, who aren't motivated to talk because, they haven't sort of axe to grind. So part of our work is to really track down those sort of witnesses and speak to them and really understand how they can help us. So it's really a combination of sort of public information and then the witness testimony, where, you know, often we get leads. They will tell us, okay, look, I've heard about this one deal that happened. You know, maybe if you look here or there, or, you know, as soon as we at least know what we're looking for, we can then sort of think, okay, where can we find this piece of information? Because often, you know, you just need to sort of piece together the puzzle in various sort of places. Often, as you mentioned in your introduction, most of our matters are multi-jurisdictional and cross-border. So, you know, you might find one piece of evidence in the Bahamas, and, you know, you need to go to the Marshall Islands and then back to, you know, the Dubai, and then, you know, at some point you end up with a property in London that changed hands from one party to the other, and suddenly you realize, oh, hang on, you know, this doesn't look right. This isn't an arm's length deal. This looks like a bribe. What happened? You know, and then you piece together the chronology of events. You see, okay, in April 2016 this happened, and suddenly 3 weeks later the expropriation happened. So, you know, it's sort of a very iterative process of finding evidence in one place and then sort of trying to piece together what actually happened.
Yeah, I understand. I would say that the Bahamas, Cayman Islands are not the worst travel destinations.
No, definitely not. I mean, sort of prior to the COVID pandemic, we traveled a lot to those places, because a lot of the information, as I said, isn't online. It's held with local registries, sometimes with local sort of corporate service providers, which is sort of a type of professional services providers that set up companies for other people. You know, you can set up a company in the Bahamas without ever going there. So, you know, you find a lawyer who will do it for you. They will do it. You know, they will run these companies for you. It'll cost you a certain amount of money to keep these companies alive. But essentially, these, you know, in these places, a lot of the information won't live online. So sometimes you're forced to go to these. I mean, forced is obviously a nice term. You know, you can go to these places and actually ask for information there. So yeah, you know, it really depends on the jurisdiction, but we do travel quite a lot because, as I said, a lot of the information won't be online. It's very confidential, and you know, I'd rather travel myself. A, it's nice to, you know, be surrounded by other cultures and sort of get to know other cultures. But B, it's quite important to do it ourselves because we know the case, we understand sort of the ramifications of certain pieces of evidence, and it's better to, you know, keep the information as close as possible, so that, you know, we know how a certain piece of evidence or information will fit the legal strategy, rather than telling someone else to go somewhere or speak to someone. It's quite important to know where the information came from, because provenance of information and evidence is quite important in legal disputes. Yeah. You often, once you introduce evidence to a court or a tribunal, you will have to explain how you got it. So if you say, okay, I got it by calling up someone who called up someone who then spoke to 5 people, that won't really go far because it's essentially hearsay. And if you go through 3-4 chains, sort of links in the chain, you know, the evidence really loses its value because you can't really explain where it came from. And also, if you don't know who the information came from, that sort of person, source A, doesn't really help because I don't know who source A is. I can't really assess their credibility. I don't know what their motivation might be. You know, whenever people talk to you, they have an agenda. You know, they will twist information, they will twist the story, they will have a narrative they want to bring across. You know, unless you really understand who you're talking to and what their motivation might be, you can't really assess the value of intelligence and evidence because you can't assess the reliability of their, you know, character, their credibility, because ultimately you don't know what they really want. Why do they talk to you? I mean, sometimes, you know, you go out and we need to find people who are actually not willing to talk to us because why would they? We can't pay them. By paying them, we would, you know, compromise all the information. So we can't pay them. We need to find people who are motivated to talk to us and who have the information that we need. So often you need to question, hang on, so you're talking to me, why are you actually talking to me? As in why they are talking to us. So unless we really do that ourselves, we can't really rely on information. Your job description is taking an interesting turn because we started on numbers and finance and money, and now it seems to me that your job is also a lot about human psychology in the end, right? Like reading people, understanding like how reliable the person is. Absolutely, yeah. A lot of that is, you know, when we prepare speaking to someone, a lot of the time that we spend on it is actually assessing who they are, what their character might be, what helps us building rapport with them, because someone might be, as I said, disinclined to talk to us, so we need to sort of find an angle that might suddenly pique their interest. So like, oh, this guy wants to talk to me, maybe I can find 30 minutes, or and that's often why we need to go out and speak to them in person, because if you call them up on the phone and then you're like, how did you find me, what do you want, sort of seeing them face to face helps a lot. But there's a massive personal element to all of the disputes. Often we deal on matters that, if we work for a large corporate entity that's making billions a year, and the conflict or the dispute is around 10-15 million, it might not be significant for them in sort of monetary terms, but there might be a personal element there where the CEO invested in this country, and suddenly he trusted the counterparties and they screwed him over, and suddenly he's got this sort of personal motivation to sort of settle this dispute. Or when we work for private individuals who are high net worth individuals who have a relationship with someone else, a business relationship, and that breaks down, and suddenly they have that sort of element of not personal vendetta or anything, but sort of there's this personal motivation to take this other person down. For example, it's like I really trusted this guy, invested a lot of money, suddenly I don't have anything, I really want to sort of sort this out. And again, it might not be about significance of the amount or the quantum of the claim. It might often be just I want to sort this out. And I mean, most of our matters are commercial in nature, but there's definitely the personal element prevalent in most of these.
Mm-hmm. How big of a role would you say are these personal elements playing compared to the money aspect? When we talked about your job and about your clients and your projects, that it's a lot about money in the first place. How big are the motivations really about the money, and how much is it, as you mentioned, about some personal background, prehistory, or other things? Could you kind of prioritize one over the other?
No, I mean, I think they sort of play hand in hand, really. For example, what I haven't really talked about yet is how I talked about how disputes come about, but how parties then suddenly decide to litigate or to arbitrate. I mean, often that's sort of based on the agreement they had in the first place, saying, should there be a conflict at some point, we will go to arbitration. And then they go through arbitration for years, and then one side will be awarded a amount of money, or a judgment, and then it says, party B owes party A 50 million. And then technically, the whole idea of arbitration, which is finding justice essentially, is that both parties adhere to that. So party B will have to pay party A 50 million. In litigation, that's a bit easier because sort of national judgments are more easily enforced.
For those who don't know these terms, could you maybe explain the difference between litigation and arbitration?
So litigation is technically any dispute that is fought over in national courts. So Germany, England, the US, anywhere around the world where you have national courts. So that's very much a national dispute resolution mechanism. International arbitration is a multilateral sort of system of dispute resolution where parties decide, usually from two different countries, decide to arbitrate rather than to litigate, because let's say they are, as I said, from two different countries, so they don't want to go to the other's home courts, so to speak, right, where they might have a home advantage. I mean, in simple terms. So they will then decide to arbitrate, which is in front of international arbitral tribunals. So you've got the most prominent ones, for example, are ICSID at the World Bank in Washington, D.C., or the ICC, which has various seats around the world, or the LCIA in London, or the Stockholm Chamber of Commerce, and so on and so forth. So you've got hundreds of these arbitration centers around the world, varying in size. As I said, the biggest are sort of Stockholm, Paris, Geneva, London, obviously Singapore, Dubai, Hong Kong to a certain extent, and then you get regional ones, the Georgian Arbitration Centre in Tbilisi, for example, but they will deal with more regional conflicts or disputes. The big centres will deal with sort of multi-billion-dollar claims. So that's technically the difference between litigation, sort of the national courts, and arbitration is sort of an international dispute resolution mechanism.
Right. And I was interrupting you before when you were trying to explain how these conflicts evolve and how do the parties decide whether they go to arbitration or litigation, right?
Yeah, I mean, well, litigation is usually, if it's quite clear cut that you want to sue someone, it's usually sort of based on the terms in the agreements of, an investment. You say, okay, as I said, sometimes it's arbitration, sometimes litigation. If there's no such thing, you will probably still try to sue them in national courts, because arbitration inherently means that both sides agree to the mechanism. So I agree with the other side that we are going to exit, or if you, for example, sue a state, the state will then say, okay, let's sort it out in international arbitration.
Right.
If the other side is probably not inclined to, arbitrate with you, you will have to sue them in their home state, or where you think you can establish jurisdiction. So, it's usually where they live or where they are incorporated and registered, and so on and so forth. So if sort of your suit comes unexpected for them, or that they won't engage, you will probably want to sue them in litigation in England and Wales, or in any jurisdiction where you think, okay, the courts are independent enough. Even if I sue them in their home courts, I will have no disadvantage there.
Right. And how do your clients usually resolve their conflicts? Let's say they start an arbitration process, they go to the law firm comes to you, you start working with the law firm. How are the conflicts usually resolved?
So, I mean, they go through litigation arbitration, which, often takes several years. Sometimes they don't even go through the entire length of an arbitration or litigation life cycle, because it's very expensive, time consuming. And often, as soon as you sue someone, the other side might want to be more cooperative, because you might, let's say an event occurs that is at the root of the dispute. And then you engage in efforts to mediate, or you engage in efforts to somehow resolve the dispute amicably. You send letters and say, look, this happened, can we sort of talk about it? And then the other side might say, yeah, actually, we like you. This went wrong. I'm sorry. Let's sort it out. Often, however, and that's when we come into the frame, is that doesn't happen. The other side says, no, yes, we know we did you wrong there, but sue us, and then that happens, and then they sue you, and then to a certain extent, then there's a bit of time until you actually go to court, go to trial, or the tribunal will start their hearings. And it's essentially at this point where we try to gather as much evidence and strong evidence as possible to present to the other side, so that the other side is motivated to say, okay, we can't win this case, let's settle now.
Yeah.
Maybe let's say, okay, your claim is 100 million, we'll settle for amount X. And that will help. If that's not the case, a lot of parties go through litigation arbitration, which takes years, at the end of which you are awarded a sum of money or not. I mean, it depends. You don't know. You might have a claim, but you might not have enough strong evidence to really prove that what happened was a wrongdoing against you, and you can't sort of establish what the damage is. But if you can, you will be awarded a certain amount of money that will be reflective of the damages that you suffered. And at this point, 75% of parties actually honor the award. When it comes to arbitral awards, the number is roughly 75%, where the award will actually be enforced automatically. So you send a payment instruction to the other side, and the other side says, yes, we arbitrated, fair enough, we'll send you the money. 25% of the cases don't end like that. 25% of the cases, the other side says, no, it's a piece of paper, we don't care. And that often happens with states, that either don't want to pay, or in the so-called global south, where they know that the award can't technically be enforced, although it's the enforcement of arbitral awards is governed by an international multilateral agreement, the New York Convention. And most of the countries of the world are signatories of that. But again, that's only a piece of paper, so you can't really trust the enforcement process. So, and that's often when we come into the frame again, when we gather evidence about the other side's assets. So, you have to imagine that the award is, a piece of paper where, the tribunal wrote down the reasons for awarding a certain amount of money. But that's just a piece of paper. And, we then start investigating what the other side's assets are.
That happens after the arbitration award, like the verdict, let's say.
Yeah, so that's a judgment. So the award is essentially a judgment. The entire text plus the number of damages awarded. We often start investigating the assets right at the start because, you want to have a head start. At some point in 3-4 years, you will have this award of a certain amount of money. The claim quantum, roughly how much you will be awarded. So throughout the arbitration, we would investigate the assets already, or sort of at least make note of assets that we come across. Right. Especially in jurisdictions where we know that the courts are more independent and where recognition of awards and enforcement of awards tends to be easier or quicker. When people talk about favorable jurisdictions or enforcement-friendly jurisdictions, it's a very vague term because the friendliness of a jurisdiction is impacted by various factors that will change from case to case. But there are certain jurisdictions around the world that are more favorable for quick enforcement of awards. And that will allow you to sort of get disclosure of the other side's awards. They may have bank accounts with cash in, or we're looking at properties, we're looking at receivables owed, or trade relationships, shipments, vessels, jets, you name it, anything you can think of that has value. But when you also earlier asked me, about the personal element and the monetary element, an asset, so anything that has value, can be various things, and where the monetary value of an asset might be low, the sort of personal value or the sentimental value of the asset might be high for the other side. When we talk about a dispute between two private individuals, when the other side doesn't want to pay out, you may want to look at assets that they hold very dear. It can be something very banal, like a dog. Sometimes a rare breed dog isn't worth, I don't know, 10, 20, 30, $40,000 pounds. So in the great scheme of things, not very valuable. If you want to be really cruel and say, okay, we'll take away your dog that you love so much, it's sort of, there are mechanisms you can do that. Or if someone has a very expensive car, but it might not be worth the entire value of the award, still, you can always argue you don't need that car. We'll give you a Fiat 500 in return. It's sort of, there are ways of dealing with that, and sort of, you just need to sort of put pressure on the other side, find vulnerabilities, be it sentimental value of certain assets, that will help sort of solve the dispute, which is a separate dispute. You have the dispute around what happened, and then you have the dispute, you need to pay me. And it's sort of the personal element there is quite important as well.
Right. The way I understood it, you basically work in two different conflict life cycles, let's call them. The first one is before or during arbitration, and the second one is after the arbitration award, when it comes to like who pays what, right?
Broadly speaking, I would say so. Yeah, you can, we are investigating things before a claim is brought, or, at the start of a litigation arbitration, throughout the life cycle, when it comes to sort of pulling together evidence for memorials or, other submissions. And then once you have the award or the judgment and you need to enforce it, that's when we also continue working on it. You mentioned before that there were also cases where an arbitration process starts, but then during the process, one or both parties realize that it doesn't make sense. They don't need the award in the end. They kind of drop out before, right? And the way I understood also your work is to basically push for that.
to push for one party or in the best case both, to not go the whole way, to also save money, right?
Yeah, I mean it depends on so many factors. I mean, a lot of claims may be settled, especially large claims. You know, last year the claim against Fox News brought by the voting machine company, can't remember the name now, but you know, the claim was huge, and ultimately Fox News settled for $787 million because they said, you know, there's an element of, you know, Fox News has enough money to pay their lawyers to go through trial, but there's an element of, okay, we don't want a lot of embarrassing information to come out. So there's an element of finding evidence that is so embarrassing that they say, okay, we can't possibly go through this trial, especially in a jurisdiction like the US, where everything is public. Civil litigation, commercial litigation is all public. It will all live on the internet at some point. You can go and listen to, you know, listen in on the hearings. So they say, I'd rather not the public know we said A, Y, Z, you know, information that is so embarrassing and confidential we don't want to get out. So if you know, where we come in, we would have to find the evidence that is so embarrassing that the other side says, look, we give up, we settle. So that's where they don't even want to go to trial. Through our trial, I guess it's sort of keep sort of working on finding good evidence, and you know, playing the evidence right to show the other side, look, you don't have a chance to win this. And then they might say, okay, look, let's not go further. Let's try to settle now. You know, there might be settlement negotiations ongoing all the time. At the moment, I'm working on a large case where, you know, they are trying to negotiate, you know, but at the same time, sometimes, you know, the situation is so, you know, personal, and you know, there's just no chance of them finding common ground. So that, you know, you have to go through the motions of suing them, you know, bringing criminal complaints and whatever not. And you know, at some point, the other side will realize, okay, the pressure is so high. Now let's come together and sit down and talk. But you know, unless you get to that point, it's about negotiations. You know, how strong are either side's positions, and you know, what are their demands really. And unless there's sort of an overlap, you don't really come to a solution. So that's why you need to sort of have, you know, dispute resolution mechanisms like arbitration, where you know, you just need to force the other side to understand, okay, you can't win this, or you know, if they go all the way through, we'll have an award against them.
Yeah. So would you say that this kind of escalation, which it is, I think, to some extent, to say we collect as much evidence as possible against you, that in your work, escalation kind of leads to de-escalation?
Yeah, I mean, I guess, you know, it's about the strategy as well. You know, speaking about escalation, I think when we try to enforce an award and the other side won't pay, you need to think about the longer term relationship with that party. You know, if it's a commercial relationship and you sort of want to maintain that even after the award, yes, they are not paying at the moment, but you know, you don't want to really ruin your relationship with that other side, because you know, you rely on them for whatever, you know, for your supply chain or whatever not. You need to be quite careful how you escalate. You know, there are various, you know, when we identify assets and, you know, see a lot of assets that might, if we were to enforce against these and sort of seize those assets, it would be very disruptive to the other side. You know, it might be sort of a holding company that manages all their, you know, distribution centers or whatnot, you know, could be anything. And you really need to think, okay, do we want to use that nuclear option that will really, you know, make their life very difficult? Do we want to do this? And we need to realize, okay, if we do this, the other side might not want to continue doing business with us. You know, that there might be, you know, they might have dispute on the one hand, but there might be business ongoing on the other. You know, if you really want to go for the nuclear option, you need to be realistic about the consequences. So escalation needs to be dealt with quite sensibly. And, you know, escalation may lead to de-escalation at some point if, you know, say, okay, we need to push the envelope long enough for the other side to understand we need to settle. But you need to be careful. You need to sort of escalate incrementally rather than going in all in and then say, okay, let's, you know, let's do this. But it really depends on the case, I would say.
Maybe to end with, what are, according to your experience, the biggest factors for successful conflict resolution in your field? Is it this, what you just mentioned before, who has the better cards, who is better in escalating situation, or are there maybe also other factors which play a role for a successful conflict resolution?
I guess the main factors would be sort of finding very good evidence, strong evidence that, you know, well, let's say we talk about the arbitration or litigation stage where you try to win the case, you will just have to find good evidence that will prove your claim. And then the other factor is the right strategy. The right strategy to, you know, legal strategy and investigative strategy have to go hand in hand. And then there are further other fields like, you know, PR, where that comes into play as well. But I guess it's the right strategy to play. When it comes to enforcement of judgments and awards, strategy again and evidence, you know, need to come together. And you know, evidence can be everything. When it comes to the personal element again, you know, so many judgments sometimes are not enforced because, let's say, you try to enforce against a state. You need to understand which minister is responsible for signing off. You know, sort of at that point, it's more about just finding assets. It's understanding the other side's motivations. You know, why is this minister not signing off on this award? You know, there might be sort of internal domestic political factors coming into play. A very personal element, you know, sometimes the minister just doesn't want to sign off on an award because there are sort of conflicts within the ministry. You know, the deputy would step up, you know, would use the award or him signing off on the award against him in sort of internal conflicts. So there's so many factors that you sort of need to investigate to really come to feed into the strategy to really understand, okay, how can we solve this conflict for our client as best as possible? Right.
We started with this idea of you working with a lot of money and in conflicts about money. And now my main takeaway is that it's about money, but it's also not about money. Toby, thank you so much for joining today. It was very interesting to talk to you, to get an insight into your work, into the different facets of what you're doing. Some taste about what litigation is, what international arbitration is. I hope it was interesting to our listeners as well. I wish you all the best for the future and hope to see you again soon.
Thanks very much, Paul. Thanks for having me.